law is geared towards exploring different contours of insolvency resolution, promoting entrepreneurship post the pandemic. Hopefully, we are moving to the normalcy, and therefore, like all systems, legal systems, I think the resolution, insolvency and resolution professionals also now has to gear towards the post-pandemic. The Center for Transnational Commercial Law at National Law University, Delhi was established in 2016 to advance the study and practice of transnational commercial law. As a university, always we are keen and we are interested in looking at how we can bring in more interdisciplinary teaching, more research, capacity building, and also creating a professionals, those who will help in a better and fine efficient dispute resolution methods. I think that's the main purpose of our Center for Transnational Commercial Law. Insolvency is a very complex interdisciplinary law, and it's one of the most critical components on the financial architecture of any country, involving a wide range of stakeholders. If we have to learn from the Insolvency Code 2016, that may be the preliminary way how the legal education, legal practice has to move forward. I think that's where the several stakeholders are coming into the legal practice. I think that where we could see 2016 IBCC explains about the future path where the legal practice have to follow and adopt. So it's critical that students of law, commerce, management, and every one of us have to work together collectively, understand the nuances of this specialized subject, insolvency, by both education and training in the field. The Insolvency Bankruptcy Code 2016 has been critical in promoting entrepreneurship as well as credit access, which have contributed towards enhancing the ease of doing business and towards greater economic growth. However, COVID-19 pandemic has led to an unprecedented situation by putting the code under one of the most critical tests in the times to come. As we have seen, the legal profession, legal practice is also trying to equip themselves. So similarly, the insolvency professionals also have to understand and move forward. The government has been prompt in reacting to the pandemic and has taken several steps to ameliorate the pains of individuals and businesses emanating from COVID-19. A good insolvency and bankruptcy regime ensures the prompt and fair resolution of financial distress, thereby necessitating the need for creating a cadre of insolvency professionals to conduct the resolution and liquidation processes. The profession and the regime for insolvency professionals in India came into existing following the 2016. Today, there are about 2,000 insolvency professionals registered with the Insolvency and Bankruptcy Board of India. I am personally, professionally, I'm more keen in looking at how we can study, understand, and develop efficient methods of dispute resolution. All of us are aware, the word resolution is very important, very key term for me under the 2016 Act, because this is an era of what we call as mediate, resolve the dispute rather than you move to more litigation. Of course, Indians are not really litigious in that sense. Professor Mark Galanter long ago has said in 1980s, when we were looking at the alternate dispute resolution as a movement which was emerging. 1980, Professor Mark Galanter said, Indian lawyers have not learned, not only just remained at the courtroom advocates, they have not learned how to negotiate, how to mediate, how to resolve the disputes. So that's where, as a student and teacher of alternate dispute resolution, I strongly look at this, how we could strengthen the resolution professionals in India. As my colleague Rishamgar has pointed out, along with this creating capacity development and also continuing legal education for the resolution professionals with the active collaboration and support of Insol India, we all have to come together and also see, along with that, how do we create entrepreneurship? I know for the last 5 years, the government of India has taken several attempts. The entrepreneurship has been emerging, startup movement has been emerging, and India is in the forerunner in this area because of our capacities. We have information technology professionals, we have the legal professionals, we have the finance and accountancy professionals. I think that's where the future, what the NLU Delhi would be more keen to work with both the IBBI and the Insol India is to how do we consolidate, how do we strengthen, how do we continue. And as I already said, as a university, we are more keen in developing the interdisciplinary courses, specialized credit courses. I think this is the future where we all have to work together and to see how we could strengthen this regime. Post-pandemic is a real challenge. How do we come over whatever the gaps which have happened during the last 9 to 10 months? I think that's where I would conclude saying that in addition to continuing professional education, which has been recognized as a planned and systematic attempt to introduce and review the competency of the insolvency professionals and also resolution professionals, and think we need to think about how we could collaborate, improve their performance. Continuing professional education is meant for post-registration development that insolvency professionals require. Since an IP needs, insolvency professional needs to be continuously up to date with the times to be able to provide value and added service. In that goal, aspiration, NLU Delhi would be happy to collaborate with all of you. On this note, I congratulate my colleague Dr. Risham Garg for organizing the symposium on the theme Insolvency Resolutions Promoting Entrepreneurship Post-Pandemic. I hope this symposium will be an eye-opener to such situations and cases. On behalf of the NLU Delhi family, I express my sincere gratitude to all the distinguished guests, delegates, sponsors, and students who have taken efforts to be present for this event. Thank you all.
Thank you very much, sir. That was very insightful. Now, may I request Mr. Amarjeet Singh Chandiok to deliver the partner address.
Thank you, Neelam. Very good morning to everybody. Dear Dr. Sahu, Chairman IBBI, Professor Shri Krishna Rao, Vice Chancellor, my dear friend, Professor Risham Garg, members of the faculty, members of Insol India, all those participants, panelists who are there with us, and dear students. It was so heartening to hear the Honorable Vice Chancellor that resolution is the need of the hour. And I think IBC, when it was thought of and enacted, and the way IBC has gone, I think resolution has been the key term in terms of IBC. At Insol India, just for the reference or a minute, we started insolvency with respect to about 2 decades ago, when we brought Insol India took its birth in India. And ever since then, we have been looking at insolvency till 2016. Our dream came true and IBC code was made. It was the first economic step by the legislature and the government, where resolution became a condition precedent before you go to liquidation. And ever since 2016, we got an award so far as best insolvency jurisdiction to the NCLT. We had that award in the world jurisdiction regimes. Ever since that, the jurisprudence that we have developed, and I must congratulate every stakeholder for it. In fact, Dr. Sahu will bear with me. Many times when we started IBC, many thought, where is that resolution profession? And today we see a great professional, 2,000 people registered. And I'm sure Professor Rao will be happy to learn that during this pandemic, on the question, notwithstanding that we had a suspension of the insolvency process because Section 7, 9, and 10 were suspended, yet between operational creditors, interse between financial creditors, we have been able to utilize this time to see how we can resolve the disputes, how we can resolve the differences. And I think I remember Dr. Sao's words in one of the webinars where we joined together, where he had said, insolvency does not mean that all your resolution process has come to an end. We have many other resolution processes, including under the Reserve Bank of India, to do so. And nothing prevents a bank or for a financial institution, for an operational creditor to sit down together and resolve it. And I'm happy to place it on record that we have been able to resolve many inter-se differences even during this pandemic, so that people can, in fact, to be honest, 3 documents have been rewritten looking at the force majeure clause, because that force majeure did not contemplate that you will have something like pandemic to therein. Therefore, parties resolved, sat down and rewritten certain covenants. That is where the development of law has taken place. And IBBI has already issued 2 papers for our comments in public domain. Dr. Sao will probably dwell on that, but more, I don't want to deal with that more. But to invite every one of us who is part of the insolvency process to give suggestions to IBBI. And I don't think in the history of this country, there is any legislation where every stakeholder has participated with passion, with commitment than in IBB. Whether it is IBBI as a regulator, whether it is the resolution professional, whether it's NCLT, including the Supreme Court. The Supreme Court has dealt with IBC matters at a much higher speed than we normally see that. I keep giving this instance to, in fact, speaking to some of when the Supreme Court judges were present, that I had the occasion as a solicitor of the country to represent the states where a suit filed on the original side of the Supreme Court could not be decided in 28 years. And I thought the matter was decided after long. Chief Justice Lodha had been pleased to pass that judgment. Therefore, resolution, as you rightly said, sir, is the time for us to look at. And mediation is one of the processes, especially after we saw UNCITRAL yesterday saying, we saw Singapore Convention and being signed. We are now looking at, in a bankruptcy, especially towards the individuals, we'll have a repayment plan. That repayment plan can always be mediated between the parties. And to tell, just to put your information, sir, I'm sure you already have it, to every one of the participants, that we have started a mediation process already. I'm already in touch with another organization, including many of the chartered accountants, company secretaries, cost accountants who are resolution professionals, to say what are the basic structures of mediation, how do we resolve it. During the pendency of the resolution process, there could be a possibility that you might have to do it. And the mediation process, we started in 2002 after the amendment of CPC. And today, I'm very happy to place on record that Supreme Court appointed an expert committee. An expert committee, of course, I was part of it. We recommended a statute. The statute has been scrutinized by the Supreme Court and sent to the government. I'm waiting for that day when we have cross-border, when we have Mediation Act into place. All steps are in the right direction for looking at what? Looking at only one thing, which is resolution. How do we bring entrepreneurship? How do we have startup agreements? In fact, I have before me an assignment where I have to look at some of the startup agreements. What should we give a template to people so that they don't have to rush here and there? So we are assisting them in looking at that part. MSMCs are looking at us to look at how we can support them. And I assure you, sir, whenever you will call upon Insol India, we shall be at your beck and call to assist you in any manner you want to further the professional team. Capacity building is one of our major concerns and major aims. We have been doing that all these years, and we shall continue to do so. I am glad that the center has been able to, we have been able to collaborate every year to do this insolvency. Dr. Isham Garg has been right in the forefront ever since then. We have collaborated with each other fruitfully, and every year have given something higher than what we gave last year. And this year is no exception to it, notwithstanding pandemic. And we see that symposium that we have today, the experts that are going to come tell us the process key issues in the resolution process, tell us how the engagement of the professional should be done by the NCLT, how should they propose a professional to be done, how liquidation has to take place. And look at the changes we have brought about. Even after we finish Section 31 proceeding, that resolution process doesn't come in place. We today have a regime to say, I can still bring a resolution and go back to bring, because the purpose is, the aim is that enterprise must come back into the society for the general good of people, the general good of economics of the country. And therefore, that is where you're doing ease of business. That's where you're helping people to come back to, because there can be a decision which may not be mala-fide. Every decision can't be mala-fide. There could be a startup which probably thought I will be able to do it but could not do it. Therefore, we need all to help. And I must put it very happily and with pride that in IBC, every stakeholder has shown his might, his passion, his commitment to the cause. And that is where we see what IBC is led in front, from front, by the regulator. Not that Dr. Sahu is here that I'm saying, I say that every day in this matter, that both NCLT, NCALT, and the Supreme Court, along with the regulator, has been able to do it. This act, which has been amended by the legislature many times, regulations come every 2-3 days. Every third week, we find a new regulation or amendment to the regulation. That only shows we are looking at the developments that are taking place and taking cognizance of it. I'm grateful to the center, grateful to you, each one of you, grateful to IBBI for giving us the lead to have this symposium. This will help us iron out many things that are in our mind, maybe professionals hearing it. The students who are going to be tomorrow the professionals would be able to understand the basic instincts of what is happening in IBC. And I'm sure we shall be able to take this forward into the might of the law. And I wanted to add to, so now I wanted to share something personal to him. I agree, sir, that we were part of advocacy. But last 4 or 5 years have changed a development today in advocacy also. And we find we are going towards, and that's why in the Commercial Courts Act, we brought Section 12A, where mediation becomes compulsory. If the Mediation Act as proposed comes through, then we'll have probably mediation as a first precondition for every step that you go to the court. Therefore, courts logging that blockage that we have number of matters comes down, we'll be able to resolve many of those disputes. And the experience of mediation at my end gives me a sense of happiness that we should be able, there's good resolution in future, we shall be able to resolve many things, both in IBC and outside IBC. Thank you very much for this opportunity to Insol India. On behalf of everybody, the governing body and everyone, I thank the Vice Chancellor, Dr. Isham Garg, Dr. Sahu, for lending us this hand, for being part of such a great discussion on insolvency and entrepreneurship. Thank you very much.
Thank you very much, sir. That was very enlightening. May I now request Dr. M.S. Sahu to deliver the inaugural address.
Respected Professor Rao, Mr. Chandiok, I think there is some echo, na? Okay, Professor Garg, my dear students, insolvency professionals, and registered valuers, good morning to all of you. I must at the outset thank National Law University Delhi for inviting me to this event. Mr. Garg just mentioned about the apparent conflict between insolvency and entrepreneurship, which to a large extent Professor Rao has resolved. So my job is simpler, but let me go to the very genesis of the entrepreneurship in the context of the Insolvency and Bankruptcy Code. If you had observed in the last year's economic survey, it was very emphatically stated that for more than 3/4 of the known economic history, India has been the dominant economic power globally. What was its secret? The secret was that the economy relied on invisible hands of the market for wealth creation. India followed a market model for wealth creation. She believed that unshackling the economic freedom augments wealth creation. If you remember, Kautilya advocated economic freedom by advising the king to remove all obstructions to economic activity. That is what today World Bank says, in the name of ease of doing business, let's remove all the restrictions that we have put on the way of the businessman to do the business. Why economic freedom is important? Because it unleashes, realizes the full potential of every person, every firm, every resource in the economy. It is well established that economic freedom and economic performance have a very high positive correlation. Countries having high level of economic freedom generally outperform the countries with not so high level of economic freedom. It has therefore been endeavor of every country in the world to provide an institutional milieu that provides, promotes, and protects economic freedom and regulates such freedom only to the extent it is necessary for addressing market failure. India deviated from this model for a few decades after independence, only to return to the roots post-economic liberalization 1990s. Since then, the thrust of reforms has been provision of economic freedom for firms and building institutions to protect and promote such freedom. A firm needs freedom broadly at three stages of business: to start a business, to continue the business, and to discontinue the business, which we call freedom of entry, freedom to competition, or fair competition at a marketplace, and freedom of exit. The first stage, freedom, enables allocation of resources to the most efficient use. The second stage enables release of resources from inefficient uses. Together, they facilitate the most efficient use of resources and consequently the optimum economic well-being. And economic reforms typically endeavors to provide economic freedom at these three stages. The reforms in the 90s focused on freedom of entry. It ushered in the liberalization. The license permit quota raj was dismantled. Discretionary license gave way to an entitlement of a registration. Privatization and globalization characterized the reforms in 90s, which facilitated free entry for firms. The reforms in the decade beginning in 2000 focused on creating a free and fair marketplace. It moved away from control of a monopoly under the MRTPC Act to promoting competition at a marketplace through the Competition Act. Size or dominance per se is no longer bad, its abuse is. And the reforms provided level playing field and competitive neutrality and prohibited restrictions on a freedom to do business from another firm. Consequently, the index of economic freedom, which measures the degree to which the policies and institutions of an economy are supportive of economic freedom, has substantially improved for India since 90s. The outcome has been astounding. The average growth rate in the post-reforms period since 1992 has been more than double of that in the pre-reforms period, that is since 1947 to 1992. To me, this economic freedom, which doubled the growth rate from in the prior to 90s, whatever period we had from 47 to 92, we used to have Hindu rate of growth. That we have doubled now after having economic freedom from 92 to 2021 now. So for about last 3 decades, irrespective of business cycle, political party in power, the growth rate has been on average 7%, except for this year when we are victim of COVID-19. This is what we had witnessed. When we got political freedom, the civil freedom, that is the growth rate from 1947 to 92 was triple the growth rate we had from 1900 to 1947. And this is the importance of freedom to our growth and development, and economic reforms has tried to provide economic freedom. So after one has business freedom to start business, to continue business, a firm in a market economy fails to deliver in 2 broad circumstances. One is if it is in an industry where business is no more viable for exogenous reasons such as change in technology, policy, trade, society, and the economy. In such cases, the firm is in economic distress and the only option available is to liquefy the assets of the firm by selling them in bits and pieces and redeploy them in viable firms, release the entrepreneur to pursue emerging opportunities. Or the other situation is, if the other firms in the industry if other firms in the industry are doing well, but only this firm is not doing well for endogenous reasons such as poor organization, inefficient management, malfeasance could be in some circumstances. In such cases, we call the firm is in financial distress and it is necessary to rescue the firm well in time from the clutches of the current management, that is the word Honorable Supreme Court used, and put it in the hands of credible and capable management. If you are familiar with Section 29A, that screens the people who can take over the company to avoid liquidation. So now the first set of situation where there is generally innovation, and the second set of reasons is where there is a competition. In both the circumstances, the firm is not able to compete, not able to survive. In competition, efficient firms drive out inefficient firms. In innovation, new order drives out old order. So while competition and innovation contribute to growth significantly, they also increase the incidence of firm failure. In a sense, failure is inherent to growth. If we want growth, we have to deal with failure. We cannot penalize failure. That is where comes the entrepreneurship. Further, when a firm experiences financial or economic stress, the resources at the disposal of the firm are underutilized. The management and the entrepreneur have failed. They are stuck up in the business. There is no way we didn't have any way to get out. Entrepreneur and resources were, in a sense, stuck up in a chakravyuha, that is the word economic survey used, and consequently we ended up with so many zombie firms and entrepreneurial talent getting wasted. So do we continue with such a state where the entrepreneurs and resources remain stuck up? Given that resources are scarce, failures are routine in a market economy, India needed a codified, structured market mechanism. As I told, the failure is coming from market forces, competition and innovation. So market should find a solution. Insolvency court allows a market determined, market initiated process to find a resolution, to put the underutilized resources to more efficient uses continuously, to release the entrepreneur from failure. That is where the growth rests. Because failures, as we say in common language, are the pillars of success. One has to fail and fail to get the success. So the insolvency reforms through the insolvency code, that provides a market mechanism to rescue a failing but viable firm. That is through corporate insolvency resolution process. Firm is failing, it is viable. The current set of people are not able to run it. Either the shareholders, managers, board of directors, they have failed. So let us bring another person to run it who can do it. Or wherever it is not possible, absolutely gone case, the market environment changed, what we call a destruction. This is the words of the Schumpeter, creative destruction. So liquidation, we liquidate such unviable ones, release the resources, including the entrepreneur, and thereby provide the freedom to exit, the ultimate freedom. The Insolvency Bankruptcy Code promises the ultimate freedom, freedom from failure, releases entrepreneur from the failure, and only when you do not penalize an entrepreneur for failure, you will have mushrooming of entrepreneurship, and then the country can grow. This is all we understand in the normal market times, but today the pandemic has come with something additional. As we know, in the marketplace, normal circumstances, there is a continuous churning which changes fortunes of businesses. Some businesses have to die, new businesses have to come up. But the COVID-19 pandemic has increased the intensity and the speed of this churning, creating new sunrise industries and new sunset industries. So the businesses need to adapt to new business realities rather than trying to preserve the status quo. Some firms would need to shrink or close and new ones to open. Jobs and resources need to move between the companies and among the sectors. The sunset businesses need to find out a resolution, not necessarily through IBC. As Mr. Chandiok mentioned, there are many ways of resolving stress. It can be the Companies Act route, it can be RBI route, it can be under no route. The debtor, creditor, the people, the stakeholders, they can sit across the table, work out a resolution plan. So these sunset businesses, whatever they use, they have to exercise, they have to be enabled to exercise their right to freedom of exit. And this is what IBC promises. But if the businesses or the state fails to notice the change in environment, if you strive to cling on to the old order, if you recall, the best illustrated by the Spencer Johnson in the fable, Who Moved My Cheese? That is an amazing story to deal with any change in work and life, and that equally applies to businesses. Change happens, change inevitable, anticipate change, monitor change, adapt to change quickly, change and enjoy change. Be ready to change quickly and enjoy it again. This is what business has to adjust to a new normal and not cling on to the old order, let it go. This is what is coming on sometimes on the way of the promotion of entrepreneurship, because sometimes the person who has built an enterprise thinks that this is what I have given my life, blood and everything to this. But through this insolvency process today, either I am ineligible under Section 29A, or because I am not able to provide the most competitive resolution plan, the firm may move out of my hands. And therefore, I do everything possible, knocking at the door of a Supreme Court 3 times to ensure that it does not go away. So this clinging on comes on the way of ultimate freedom, economic freedom. This is one. And the second is, sometimes we think that liquidation releases both entrepreneur and resources, but we feel that liquidation is not a good thing. We believed this so far, but the cost that we have suffered not allowing the zombie farms getting liquidated, that is enormous cost to drag on the economy. As you know, IBC was enacted to resolve the stress. Therefore, some believe that the process, as Mr. Chandiok mentioned, there is resolution is a focus, but resolution, we have to understand, resolution is not necessarily that it is you make an attempt to rescue the company, but you may fail even after making the best efforts. So today we see that prima facie the data show that of the 1,300 companies which have completed the entire CIRP process, of them about 300 or so, they have been rescued. And balance, that means about 75% of companies have proceeded for liquidation. So 25% companies rescued, 75% proceeded for liquidation, and therefore some argue that code is not delivering on its mandate. These numbers do tell a story, but not the entire story. Let me tell the story what I understand, and I will use now figures here for roundabout figures for quick appreciation. First, let me clarify that the CIRP enables market to first attempt to resolve stress through a resolution plan whereby the company survives. When the market concludes that there is no feasible and viable resolution plan to rescue the company, or liquidation maximizes value as compared to rescue, the company proceeds for liquidation. Thus, the code enables 2 ways of resolution of stress. First, by resolution, failing which by liquidation. Liquidation is also a means of resolution under the code. So the market usually rescues a viable company and liquidates an unviable one. Let me give you 1-2 examples. So let me give you 1-2 examples. Two companies which got media attention, namely the Ghotiringa Minerals Limited and Orchid Healthcare Private Limited. These together owed about 8,500 crore to creditors, while they had absolutely no assets and employment, absolutely zero. They existed only on the records of the ROC when they entered CIRP. There are quite a few such companies which have negligible asset and or are defunct when they entered into CIP. They have been BIFR for decades. So many of these are beyond the rescue for a variety of reasons, including creative destruction, and their continuation is a cost to the economy. In such cases, the code enables liquidation to release available resources to alternate uses. I don't see any reason to now feel bothered that why this Ghotiranga and Orchid Healthcare are getting liquidated. Newspaper told that 8,500 crores banks were to get money, but they are getting absolutely zero. This is what IBC is doing. But please note that there was absolutely zero assets, zero employment, zero production, everything zero. And how do you think that a company existing only on paper will revive back? So there, I don't see that there is an anxiety over liquidation in such cases. Therefore, what I want to say is that liquidation is not necessarily bad. If it is a viable company which is getting liquidated, it is a concern. That is why the insolvency law, in the wake of COVID-19, when there was a feeling that when there is a concern about the availability of resolution applicants, the law was suspended to protect the companies which were doing well earlier but not doing well on account of COVID only. Such distress was kept out of IBC forever. So the idea is that we do not want a viable company to be liquidated, but we should not lament if an unviable company or where there is creative destruction required, such company is liquidated. Let me come to these numbers. 25% rescued, 75% proceeded for liquidation. These are the percentage of the companies. But if you look at in terms of value terms, how the assets were rescued, 75% assets were rescued. That means 25% of companies, 300 companies which were rescued, they had 75% of the assets that was rescued. The 75% of companies which were liquidated, they had only 25% of assets which proceeded for liquidation. And of these, the companies which were rescued, 1/3 of them were defunct despite that they were rescued. And the companies which are liquidated, 3/4 of them were in BIFR defunct. The companies which were rescued, they had on average about 20 to 23%, had the assets valued at 23-24% of the amount of claims against them. The companies which proceeded for liquidation had assets valued at about 5.5-6% of the amount of claims against them. So if you look in terms of these facts, the extent of liquidation may not appear worrisome. Now let me tell you, the stress that a company suffers is like illness of an individual. An individual suffers. Allopathy is one of the options to treat illness of an individual, other options being homeopathy, Ayurveda, etc. Similarly, code is one of the options for resolving stress of a company, other options being schemes of arrangement under the Companies Act, Prudential Framework of RBI, etc. Allopathy is a system to treat illness. It is not just something, it's a complete system, holistic way it treats the problems in the society. It offers vaccinations and lifestyle guidance that aim to prevent illness. Patients treat some illness with the over-the-counter medicines. We do not have data about these kind of preventive or self-treatments the patients get. But where illness could not be prevented or treated otherwise, a patient visits a doctor. From this time onwards, we have Pakka data. Most patients get relief at the outpatient department of a primary health center. Patients with a complicated illness move to a secondary care hospital, more complicated ones to a tertiary care, and the most complicated ones to quaternary care. Normally, recovery is better if diagnosis and treatment starts early. When the illness is at an advanced stage, some patients survive while some may not, despite the best efforts of the doctors. The percentage of survival at this stage may not be significant, but the number of patients who recovered in OPDs and at primary, secondary, tertiary care hospitals as a percentage of those who visited a doctor gives a fair idea about the efficacy of allopathy as a system for treatment of illness. We need to look at IBC similarly. The code is a system to address stress of a company. The credible threat that of CRP that a company may change hands has redefined the debtor-creditor relationship. With the code in place, in the words of Honorable Supreme Court, defaulters' paradise is lost.
Your iPad first.
A debtor makes all-out efforts to prevent the stress. It resolves stress on its own when it is imminent, much before it translates into a default. It makes all possible efforts to settle default to prevent filing of an application for initiation of CRP. Even after an application is filed, it tries hard to resolve the stress to avoid admission. It continues efforts to resolve stress midway through settlement, review, mediation, or withdrawal to avoid consequences of CRP. And there are also examples of settlement with the approval of the apex court. So about 30,000 applications have been filed for initiation of CRP. Of them, 10,000 are yet to be disposed of. Of the balance 20,000, the stress underlying 16,000 applications were resolved before admission, and stress underlying 4,000 applications entered CRP for solution. Of the 4,000 CRPs, 1,900 are ongoing. 800 got resolved midway through settlement, review, mediation, withdrawal. Balance 1,300, as I told in the beginning, completed the process. At this stage, the value of the company is substantially eroded, and hence 300 of them were rescued, about 1,000 liquidated. So one may work out 300 upon 1,300 to find a rescue rate of 25% of CRP. But one can also work out the number of companies where stress was resolved before admission, closure midway, through resolution plan as a percentage of the number of applications concluded. We get a rescue rate of 95%. So only 5% of the companies seeking resolution through the code end up in the liquidation. As I mentioned earlier, of this 5%, 75% of this 5% are defunct to start with. Liquidation or rescue is an outcome of market forces. The law is only an enabler giving choices and nudging towards value maximizing outcomes. The stakeholders decide whether to seek resolution. If so, the mode of resolution. They weigh various options and choose the one that best suits their needs. They will not use the code if they find that outcome under it is not consistent with the market realities. Further, when they use the code, they have a choice between the rescue of the company and its liquidation. And they prefer liquidation when it serves their interests better. The invisible hands of the market work towards the best outcome, which we should respect and accept. The insolvency reforms, as Mr. Chandiyoga mentioned, is a road under construction. We have seen on daily basis something is happening through enactment, subordinate legislation, new jurisprudence. Insolvency today boasts of probably the largest body of case laws. The insolvency reforms will remain as a road under construction till the ultimate economic freedom, as I mentioned, the freedom to exit or freedom from failure, becomes a reality and Indian society starts celebrating it. So the code endeavors to rescue lives of companies. Rescue may be neither desirable nor feasible, where creative destruction is a driving out failing unviable firms from the market. And with the COVID, there is a new readjustment to be done. See, the code provides a mechanism whereby a failing unviable firm exits with least disruption and cost, liberates the entrepreneur from failure, releases idle resources in an order of fresh allocation to efficient users. Growth needs entrepreneurs. Code aims to promote entrepreneurship by providing an effective mechanism to liberate entrepreneurs from honest failure. I emphasize honest failures instead of penalizing them. Honorable Prime Minister of India, in one of his addresses at the centenary celebrations of Kirloskar Group on January 6, 2020, he emphasized this aspect when he stated that ये जरूरी नहीं है कि जो कंपनी सफल ना हो रही हो उसके पीछे कोई साजिश ही हो, कोई गलत इरादा हो, कोई लालच हो, यह जरूरी नहीं है। इसमें ऐसे उद्यमियों के लिए एक रास्ता तैयार करना आवश्यक था और आईबीसी ने इसका आधार तैयार किया। आज नहीं तो कल इस बात पर अध्ययन जरूरी होगा कि आईबीसी ने कितने भारतीय आदमियों का भविष्य बचाया, उन्हें हमेशा हमेशा के लिए बर्बाद होने से रोका। This is the key outcome of the Insolvency and Bankruptcy Code. We want entrepreneurship, and given that India is a kind of cradle for startups, we need to liberate entrepreneurs from failure. So this is what the Insolvency Code intends. With this, I conclude. I thank once again NLU Delhi, Professor Garg, Professor Rao, for giving me this opportunity. Thank you.
Thank you very much, sir. That was very enriching. May I now request Dr. Resham Garg to deliver the vote of thanks.
Honorable Dr. M.S. Sahu, respected Vice Chancellor Professor Rao, respected Shri Chandiyog ji, there is very less for me to say now after that illuminating and enriching disposition of insolvency, resolution, and entrepreneurship by the Honorable Chairperson. Sir, I would like to, as you have already seen, this day we have 5 sessions and we have curated these sessions in a structure. The first session is on CIRP, second is on liquidation, third contains those schemes of arrangement, then fourth we have cross-border insolvency, and fifth we have MSME resolution and entrepreneurship. So although it's a long day, it's a long session, but we have tried to make a comprehensive structure in this symposium. As Honorable Vice Chancellor has already mentioned, the global COVID-19 pandemic and its consequential lockdown have created an economic ripple effect on businesses in India and abroad. To mitigate its impact, the governments in several countries have introduced their last tranche of economic reforms. So India also imposed certain temporary reforms. Now, in this background, this symposium, as I've already mentioned, was conceived as a platform to enable policymakers, academics, and professionals from different parts of the world and from different spheres of work to engage on various issues relating to transnational commercial law, insolvency law, restructuring, entrepreneurship, trade and development post the pandemic. Sir, I am very happy to inform you that we have received around 500 registrations from insolvency practitioners who are likely to view this event. Even at this point, if you can see, there are over 200 participants who are already joined in. And I would also like to take this opportunity to mention that whomsoever professional we approached, we were very lucky and we were blessed to have the support from the best of the practitioners in India. And as you can see the lineup, I think that we received positive response from everybody whom we approached. So at the end, I would like to extend my heartfelt gratitude to all the support which has been provided by the Insolvency and Bankruptcy Board of India, several officials who have been coordinating this program, and several officials who are participating as key speakers in this schedule. The UNCITRAL Regional Center for Asia and the Pacific, whom we have been partnering now. This is the 5th year in a row that we are organizing this UNCITRAL Symposium. Are very valuable partners, Nottingham Law School, Nottingham Trent University, UK, the Norman Adrian Wiggins School of Law, Campbell University, UK, the Center on Transnational Business and the Law, Georgetown Law, the International Law Institute, Washington, D.C., and very valuably, the UNCITRAL Coordination Committee of India, and the most important, generous support from Insol India, Mr. Chandiok, and all the officials of Insol India. So this symposium has been possible with the generous support and full-fledged support from Insol India. And I also like to thank all the participants who have taken time out from the day to day. Today is a working day for several people, and they have been participating, and we have been receiving several queries regarding their registration and participation. Sir, I hope that this conference will be an eye-opener to such situations and that all participants have the opportunity of learning from top professionals in the field. On behalf of the National Law University family, I express my sincere gratitude to all distinguished guests, delegates, sponsors, and students who have taken effort to be present in this function. All events in the Law University are successful through the efficient team, which is led by the Vice Chancellor, Professor Rao, the Registrar, Professor Bajpai, and we have good supporting staff and our faculty colleagues who provide us support at every step of the way. So with this, I thank one and all for joining this inaugural session, and I would request them to continue. The next technical session will start immediately after at 11:15, and I wish all a great enriching session day ahead. Thank you one and all.
Thank you.
Thank you, sir.
So I think the next